So I have an update in the force reset trigger lawsuit against the ATF and its current review by the Fifth Circuit. So let's talk about what is happening. Now, before we jump into the video, I want to thank one of the sponsors of the channel, which is 1st Phorm. 1st Phorm is an amazing company. They have amazing supplements. I use them every single day, but also they're pro-freedom, pro-America. Now they're actually doing a hunting giveaway. I believe the prize is up to $4,500, a bow, and some other products. So if you guys are interested, check out 1st Phorm using the links down below. Also, my special link will also get you a free 4-pack of energy drinks if you order something. Now, as I mentioned in the intro, in this video, I have some major news in the battle against the ATF and the restrictions on forced reset triggers. You may recall that earlier this year, we received a significant win by a lower court judge, Judge Reed O'Connor, who granted NAGR and Rare Breed their motion for summary judgment. That means that he reached a final decision, which ultimately struck down the ATF's FRT restrictions, and he found that their actions were in fact unlawful and that the ATF engaged in overreach. That decision came in a critical case called NAGR versus Garland. Now, in response to that decision, the ATF has now appealed up to the Fifth Circuit, but at the same time, we talked about how the ATF was trying to get Judge O'Connor to place a stay on his decision and then also put a halt on the return of devices, which was ordered in that decision. Now, in fact, Judge O'Connor has denied that request. He is not staying his decision, so the FRT rule is still blocked. However, he did give the ATF until February to return all those items and to send out the required notice. However, now that decision from Judge O'Connor is up for review in the Fifth Circuit. The ATF wants the full decision to be reversed, and so we need to talk about what is now happening in this appeal and what the ATF is arguing. Now, this whole case arises out of the unlawful actions by the ATF trying to change the definition of machine guns under the GCA and NFA. They want the term machine gun to include items like force reset triggers. Now, as a result of that, then Rare Breed filed lawsuits, and eventually they partnered with NAGR in a federal district court in Texas to sue the ATF. Originally in that lawsuit, Judge O'Connor granted a preliminary injunction in favor of the plaintiffs, and ultimately he did reach a final decision striking down the entire rule, finding that it was unlawful, that it was beyond what the ATF could do, and that the GCA's definition of a machine gun does not include items like FRTs. Now, in coming to that decision, he primarily leaned on a different decision, which was Cargill, that came out of the Fifth Circuit and was ultimately then ruled on by the Supreme Court in a 6-3 decision. Judge O'Connor in his decision stated that function and pull are not synonymous. The former is based on a mechanical perspective, whereas the latter is based on the shooter's perspective. He went on to state that applying the guidance from both Cargill decisions, here the FRTs do not fire multiple rounds by a single function of the trigger and thus do not qualify as a machine gun. So we all knew that the Cargill decision would have important trickle-down impacts on other FRT and ATF cases. That has now happened in this specific case, and that whole perspective about single function of the trigger, single pull of the trigger is also being reviewed now by the Fifth Circuit. Judge O'Connor also in his decision stated that rather than respect this intentional feature of our democratic system, defendants chose to advance a policy agenda wholly divorced from the NFA statutory text. Thus, to allow the defendants, the ATF, their unlawful action to stand would be to functionally rewrite the NFA. That is not how our democratic system functions. Indeed, it is never a court's job to rewrite statutory text. Marshall put it, it is emphatically the province and duty of the Judicial Department to say what the law is, nothing more. This remains true even when shocking events may underscore the need for legislative change. And even when this prudent constraint produces undesirable results, one must remember that circumventing the democratic process to effectuate desired change undermines the animating policy goals upon which our system rests. A democratic path to change already exists. Each time an agency circumvents the legislative process, it chips away at the most prudent reason for the separation of powers. That is, ensuring unelected and unaccountable individuals do not make the law. This reason alone compels this court's decision today. And based on that, he vacated the ATF's classification of FRTs as machine guns, vacated that rule and found that the ATF engaged in overreach. And as a result of that decision, he then enjoined the ATF from enforcing those restrictions against the plaintiffs, the organizational plaintiffs, their members, and any customers of those companies, as long as it did not violate or contradict any of the other injunctions that were going on in other jurisdictions like the lawsuit in New York. Now, also in that decision, Judge O'Connor, he ordered that the ATF had to comply with two obligations. The first obligation was that the ATF had to return 11,000 FRTs within 30 days that they had confiscated. And also the second obligation was that they had to send out a notice to all individuals involved in this issue that ATF rule was now invalid and had been reversed. But in response to that, there were arguments to Judge O'Connor that first he should stay that whole decision. He should stay it that the 30-day notice and the 30-day return should not go into effect because the ATF was going to appeal to the Fifth Circuit. But they also argued in the alternative that they should get an extension of time because they argued, the ATF, that they could not return all these items within the 30 days. Now on review, Judge O'Connor denied the stay, so his decision is still in place. However, he did give the ATF until February 22nd to return all of these items. So if you specifically had an item confiscated by the ATF and you have proof of that, right now the organization NAGR along with Rare Breed are working on the return of those items, so you can reach out to NAGR specifically for the return of those items. So that's what's going on. The ATF did get an extension until February 22nd to return all those items. Now, as of right now, there is still an appeal going on in the Fifth Circuit. The ATF has filed for that appeal. They want a reversal of the Judge O'Connor decision. The Fifth Circuit recently issued an order for the expedited briefings and hearings in this case. The ATF, in their opening brief, also has now argued that the Fifth Circuit should just outright reverse everything that Judge O'Connor said. They argue that Judge O'Connor got the analysis wrong. He should not have relied on Cargill, that the Cargill decision by the Supreme Court really has no impact on this case at all. They argue that the bump stock issue is different from the FRT issue. And they also argue that the ATF has always considered these types of triggers, these types of devices to be machine guns. And they argue that has been their perspective for 50 years. They state in the brief that the court was mistaken in all respects. As noted, the ATF's treatment of devices of this type as machine guns long predates the 2018 bump stock rule. The Supreme Court's application of the machine gun definition in Cargill reinforces rather than undermines that long-standing view. As the court explained in Cargill, the hallmark of an ordinary semi-automatic rifle is that for each shot, the shooter must engage the trigger and then release the trigger to allow it to reset. The entire point of the device at issue here is to relieve the shooter of any need to release and re-engage the trigger or take pressure off the trigger for each shot. Because a shooter may fire multiple shots while engaging the trigger only once, these devices are machine guns, and that is what the ATF is arguing. So the ATF is claiming that the Supreme Court's recent Cargill decision actually supports how they are interpreting FRTs to be machine guns. They are trying to say that the mechanics involved in the bump stock maybe did not meet the definition of machine gun, but they say the mechanics of FRTs does fit the definition of what a machine gun is. Now, we all know that mechanically that is not true when it comes to FRTs. With an FRT, there is still a single pull of the trigger, there's a single shot and then a reset, and then there is a secondary pull that creates a secondary shot. So the mechanics of an FRT do not meet the definition of what is going on with the GCA. Simply the FRT kind of makes the shot and reset happen faster, but there is still a single shot, a reset, and then a second pull of the trigger. However, the ATF's new entire brief tries to characterize multiple shots by a single pull of the trigger, and so they are trying to say that this is all happening within a single pull. The ATF is also trying very hard to claim that the Cargill 6-3 decision by the Supreme Court does not impact this case at all. They say that Judge O'Connor should not have relied on Cargill, and they say that these two devices are so different that this does not apply. Now, in my opinion, I don't think that's going to work because also remember the Cargill case came out of the Fifth Circuit. It was a decision originally issued by the Fifth Circuit. The Fifth Circuit mechanically struck down the ATF's rule of bump stocks, finding mechanically that bump stocks did not meet that definition. So I don't think the ATF is going to win this argument. But as of right now, NAGR and Rare Breed are set to file their response to this. And in the meantime, the FRT rule is still blocked and the ATF still is required to return all these products by February 22nd. But like I said, there is an appeal going on right now, so we're gonna have to watch how this plays out. And if we get any more information, if anything else changes, I will let you guys know. Also, if you like this video, and you like support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of 2A news. But as always, thank you all for watching. Don't forget to like and subscribe, and never forget this nation was built by armed scholars, and this nation will be maintained by armed scholars.